Sir, if we come down to page number 35.
Page number?
35.
So there are three cases.
Only one case. That MCRC is connected matter,
I
Manoj.
think 13.
If the revision is disposed of,
Go ahead. 13 and 13.1. Connected case क्या है?
482 है क्वाइशमेंट and charge के खिलाफ revision
That is against the charge.
against charge.
Achha, all right. Yes. So in the FIR, where is the allegation against you?
In the FIR, there is no allegation against me.
No, there must be some allegation that amount was credited in your account.
The allegation that the amount of
Where is that? Where is
kindly see page number 35
35?
of MCRC number
So it's a very long FIR.
CRR में आ जाए सर CRR
35.
जी
Yes.
of the CRR
Hmm. CR?
CRR
Not MCRC.
no not MCRC it can be
Yes.
Or as emphasized by him for referring the case to a larger bench. We have observed that the exceptional circumstances as indicated in para 8110 or Indra Sahni were not exhaustive, not illustrative. The Constitution bench, however, has given indication of what could be the extraordinary circumstances for exceeding the limit of 50%. The Commission has noticed the majority opinion in Indra Sahni. We may notice para 234, chapter 10 of the report, which is the following. My lord, this I would like to skip. Then I am coming, my lord, to para 462. That is the next page, 243. After noticing, para 462, my lord, after noticing the above proposition of law, the Commission proceeded to detail with the subject. In para 234, the Commission has noted the Constitutional Bench judgment in M. Nagaraj versus Union of India, observing that this court has again considered the aspect of ceiling of 50% reservation. The Commission, however, proceeded with an assumption that in Nagaraj, this court has ruled that for relaxation 50%, there should be quantifiable and contemporary data. We may notice the exact words of the Commission in para 234, which is of the following effect. The Honorable Supreme Court, I quote, my lord, the Honorable Supreme Court has again considered this aspect of ceiling of 50% reservation in its next decision in M. Nagaraj versus Union of India, wherein the Honorable Supreme Court considered the validity of inserted clauses by way of an amendment to Article 16 of the Constitution. However, in Nagaraj, the Honorable Supreme Court has ruled that for relaxation, that is ceiling of 50%, there should be a quantifiable and contemporary data. The above view has again been reiterated by the Commission in para 235. 235 quotes. However, it is seen from Nagaraj that ceiling of 50% reservation may be exceeded by showing quantifiable contemporary data relating to backwardness as required by clause 4 of Article 15 and clause 4 of Article 16. From the above, it is clear that Commission read the Constitution bench judgment of this court in Nagaraj, laying down that ceiling of 50% reservation may be exceeded by showing quantifiable contemporary data relating to the backwardness. The above reading of the Constitution bench judgment by the Commission was wholly incorrect. We may notice the judgment of M. Nagaraj in the above respect. M. Nagaraj was clear, where the Constitution 85th Amendment 2001 inserting Article 16(4)(a) was challenged on the ground that so-and-so. Now, my lord, para 465. The Constitution bench proceeded to consider the submissions raised by the petitioner challenging the constitutional validity of the Constitution. My lord, I am skipping all this, coming directly to para 466. 466 says, in para 107, the Constitution bench observed, quote 107, if the state has quantifiable data to show backwardness and inadequacy, then the state can make reservations in promotions keeping in mind maintenance of efficiency, which is held to be constitutionally limitation on the discretion of the state. Now, my lord, 467, I am skipping, coming directly to 468. The Constitution bench in para 123 held that provisions of Article 16(4)(a) is an enabling provision and the state is not bound to make reservations for SC/ST in the matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class and inadequacy of the representation. The above observation regarding quantifiable data was in relation to enabling power of the state to grant reservation in promotion to the scheduled caste and scheduled tribes. This is the most important paragraph, my lord. The words. Again, I would like to read. The above observation regarding quantifiable data was in relation to the enabling power of the state to grant reservation in promotion to the scheduled caste and scheduled tribes. It is further relevant to notice that in the last sentence of para 123, it is stated so and so. It is made clear that I am skipping this, my lord, and I am turning, my lord, and coming now directly to para 472, my lord, which is the crucial paragraphs, 3-4 paragraphs, which is the most important paragraphs of this judgment according to me, my lord. 472, page 246, my lord. Regarding the before that, my lord, the quantifiable data discussion is there in para 471, but that I am skipping. 472 says, regarding the above noted quantifiable data, my lord, just before that, just last line of 471 quotation I would like to read. So as total, 84.3% population can be said to be of backward class. That is of Maharashtra, my lord. So there, the population, here the population is just 54%, 52%, my lord, 52.5. So they are saying that 52% population of OBC should not be given 14%, but 27%. Here the population ratio in Maharashtra was 84.3. So at 472 paragraph, my lords have said it. Regarding the above noted quantifiable data, the Commission has recorded its reason for reservation under 15.4 and 16.4 in para 259. We extract here para 259 to the following effect. To sum up, this Commission already found above an appreciation of evidence collected produced before it that 80 to 85% of the population state of Maharashtra is backward. According to this Commission, to accommodate 80 to 85% backward population within a ceiling of 50% will be injustice to them, and as such, it would frustrate the very purpose of the reservation policy arising out of Article 15 and 16 of the Constitution. In the considered opinion of this Commission, this is the extraordinary situation which has been mentioned in the second term of reference as required by Indra Sahni. 80 to 85% backward population adverted to above speaks about quantifiable contemporary data, White Nagaraj. If accordingly, ceiling of 50% increased efficiency in the administration could not be effected because all of them would compete, This commission records facts finding that as required by the second term of reference, there are not only exceptional circumstances but also reservation in the present context in view of clause 4 of 15 and subclause 4 of article 16 of the Constitution. This will enable the government of Maharashtra to make special provisions for the advancement of Maratha community, which is certainly socially and educationally backward class, and ultimately that will enable the government of Maharashtra to make provisions for reservations or appointment of posts in favor of Maratha community in the services under the state. Unquote. It is clear that the entire basis of commission to exceed 50% limit is that the population of backward class is between 80 to 85% reservation to them within the ceiling 50% will be injustice to them. We may revert back to para 810 where Indra Sahni has given illustration, which illustration is regarding certain extraordinary situation. The exact word used in para 8110 are 8110, I quote, "It might happen that in far-flung and remote areas, the populations inhabiting those areas might, on account of their being out of the mainstream of national life and in view of the conditions peculiar to the characteristic to them, need to be treated in a different way. Some relaxation in this strict rule may become imperative. In doing so, extreme caution is to be exercised and a special case made out." Shri Rodgi had submitted that the test laid down in para 810 is only geographical test, which was an illustration. It is true that in Indra Sahni the expression used were far-flung and remote areas, but the social test, which was a part of the same sentence, stated the population inhabiting those areas might, on account of their being out of mainstream of national life and view of the conditions peculiar to and characteristic to them. Thus, one of the social conditions in para 8110 is that being within the mainstream of national life, the case of Marathas does not satisfy the extraordinary situation as indicated in para 810 of Indra Sahni. The Marathas are in the mainstream of national life. It is not even disputed that Marathas are politically dominant caste. This court in several judgments has noticed that what can be the extraordinary situation is contemplated in para 810 in few other cases. We have referred above three judge bench judgment in Union of India versus Rakesh Kumar and so and so. Now I'm coming directly to next page 477. Extraordinary situation. Opinion of the commission that when the population of backward class is 85%, if they would get only 50%, it would not be valid. In para 275 of the impugned judgment, the following is the opinion of the High Court. Jayashree Patil versus State of Online. Quote, "The percentage of other closed classes of population who have not disclosed their caste have been shown to be 15.7%. The commission therefore concludes that though the survey report relates to rural areas, the total percentage of existing backward classes, Maratha plus Kulbi,
Come to 480.
480, my lord. Yes, my lord. That is the crucial, my lord. From the above, it is clear that that both the Commission and the High Court treated the extraordinary situations with regard to the exceeding 50% for granting separate reservation to Marathas. The fact that population of backward class is namely that there should be equality of opportunity. It cannot be in any judgment. Therefore, the seats to be reserved with the reservation is to be consistent with clause 1 of Article 10, must be confined to a minority of seats. It is then only that the first principle could find its place in the Constitution and effective in operation. Unquote. The illustration given by Dr. Ambedkar that supposing 70% posts are reserved and 30% may retain as unreserved, can anybody say that 30% as open to general competition would be satisfactory from the point of view of giving effect to the first principle of equality? The answer given by Dr. Ambedkar was in the negative. Thus, the Constituent Assembly, by giving illustration, has already disapproved principle which is now propounded by the High Court. We cannot approve the view of the High Court based on the same view taken by the Commission. In view of the discussion and conclusion of the commission are unsustainable. We thus hold that there is no case of extraordinary situation for exceeding the ceiling limit of 50% for grant of reservations to Marathas over and above the 50% ceiling of reservation. Now, my lord, I am coming directly to page 491. Last three lines of page 253, para 491.
Madam.
It is well settled that all legislative act and executive acts of the government have to comply with the fundamental rights. The state's legislature or any executive action passed in violation of fundamental rights is ultra-virus to the constitution. The 50% ceiling limit for reservation laid down by Indira Sahni is on the basis of principle of equality as enshrined to Article 16 of the Constitution. Then my lords have quoted each and everything, my lord, and they have scrutinized in para 494 the Gaikwad Commission report. Now, my lord, coming to the last few paragraphs of the judgment, my lords have said it, my lord, in page 323, the conclusion. That is para 687. That is the last but one paragraph. The matter ends.
Yes.
Conclusions. From our foregoing discussions and finding, we arrive at the following conclusion. The greatest common measure of agreement in 6 separate judgments delivered in Indira Sahni is reservation up to 16 subclause 4 should not exceed 50%. For exceeding reservation beyond 50% extraordinary circumstances as indicated in para 810 of Justice Justice Reddy's judgment should exist, for which extreme caution is to be exercised. The 50% my lords have said it again. I would like to read what was held by the Constitution Bench on Indira Sahni. The relevance or significance of no, sorry, my lord. The second paragraph. The Constitution Bench in Nagaraj does not contain any ratio that ceiling of 50% reservation may be exceeded by showing quantifiable contemporary data relating to backwardness. The Commission has completely misread the ratio of the judgment when the Commission took the view that on quantifiable data, ceiling of 50% can be breached. The Commission and the High Court found existence of the extraordinary situations with regard to exceeding 50% ceiling in respect to the grant of separate reservation to Marathas because the population of backward class is, and therefore 27% increase of reservation. My lord, I respectfully submit that if 27% is increased, is allowed to be increased, and it is declared as intra-virus, then the total reservation will come to 63%. And although that matter is pending before the Honorable Supreme Court regarding EWS, but 10% EWS is also being provided in the state of Madhya Pradesh. So 63% of SC, ST, OBC and 10% of EWS comes to 73%. Then there comes physical disability, and all my lords know it very well. My lord, what remains for the general category? So this cannot be the basis, that population can be the basis for increasing the reservation in a state of Madhya Pradesh at any cost.
All right.
That is my respectful submission.
Yes.
I'm highly obliged, my lord, that my lord gave me a patient hearing. My lord, my written submissions as well as the list of books are before my lords.
Yes. Yes, somebody else.
My lord, I would just like to read one thing, my lord. On 25th of August 2021, an opinion was given by the learned Advocate General, and after that 25th of August 2021, the notifications were issued which is under challenge. So when my lords will decide, as far as 5901 is concerned, my lord, that is the original ordinance as well as the act. But as far as other petitions which are connected, that notifications came after the opinion of the learned advocate general at that time on 25th August 2021. So all those notifications are of October, November 2021, which has been stated by my lords. So I just want to make it clear to my lords that those are the difference. Highly obliged.
My lord's permission, my lords.
Anything you want to add?
My lord, there is.
There is.
If your lordships would permit, my lord, I'll commence tomorrow, my lord, so that I am able to finish. My lords.
That means Mr. Sanghi has left something.
No, my lord, I wouldn't dare say so. My lord. I will make my own efforts, my lords.
All right. Then we'll continue tomorrow.
My lords.
Well, the matter is partly heard. The arguments of Sri Sanghi, you are in this same case.
My lords, I have a separate petition. Separate.
Well, I have represented total 10 matters.
Acha. The matter is
Highly obliged.
all right. 3:30 ka bhi. Let's start it. Tomorrow 3:30.
Highly obliged.
That's all. और कोई नहीं है? All right. 3:30.
ठीक है दोस्तों, ये सुनवाई यहीं पर ख़त्म हुई है। शायद ही बहुत से लोगों को समझ में नहीं आया होगा, बहुत से लोगों को समझ में आ गया होगा। तो कुछ ही देर बाद इसका एक हिंदी में वीडियो बताऊंगा, मैं वीडियो बनाने वाला हूं कि लाइव सुनवाई में अपन ने सुना क्या। बहुत से बच्चों को नहीं समझ में आया होगा क्या सुना अपन ने। सभी लोग चैनल को सब्सक्राइब कर दीजिए फटाफट, क्योंकि कुछ ही देर में इसका लाइव यानी हिंदी में वीडियो आने वाला है कि आज की सुनवाई का रिजल्ट क्या निकला है। ठीक है दोस्तों, इसको यहीं ख़त्म करते हैं। धन्यवाद। जय हिंद, जय भारत।